My name is Ryan Park, and I clerked for Justice Ginsburg last year, and after that I spent some time at home with my daughter, and I wrote an article about that experience. And the justice was generous enough to sit and answer a few questions that kind of came up in the course of writing the article. So when you were in law school, as I read about in the article, you had a newborn daughter. And can you talk about that experience and what insight that gave you into work-life balance issues?
When I started law school, my daughter Jane was 14 months. So at the end of the first year, she was about the same age as your daughter is now. And I attribute my success in law school largely to Jane for this reason. Unlike you, lately you've been spending all day, every day with your daughter. I went to class about 8:30 and had an excellent nanny who took care of Jane, who left at 4 o'clock. So I came home at 4 o'clock. That was children's hour. It was a total break in my day from being with the books and listening to attending classes, and children's hours continued until Jane went to sleep. Then I was happy to go back to the books. So I felt each part of my life gave me respite from the other, and I wasn't so overwhelmed thinking that it was my whole world was the law school. I think I had a better balance, a better sense of proportions of what matters. I'll tell you, I appreciated that when Jane came out to the living room where I was with my typewriter and my books, and her mouth was filled with mothballs. Well, we went off to the Cambridge City Hospital, had her stomach pumped, and thank goodness she hadn't actually ingested any of it. The doctor said, it would have been such an interesting case if she had, but when that child was screaming, and then I realized that the practice exams which were coming up were not all that important. And I must say that I was blessed with a husband who believed, he had read somewhere that a child's personality is formed during the first 2 years of her life. So he wanted to put as much of himself as he could into Jane.
So how did that change as your children got older and you had progressed in your career?
At different times in our life, one deferred to the other. So when Marty was intent on making partner in a law firm in 5 years, I took over most of the responsibility for Jane. But when the women's movement came alive at the end of the 60s and I co-founded the ACLU's Women's Rights Project, Marty realized how important that work was. Mm-hmm. In those years, he took over the kitchen entirely, and I was phased out of it to the everlasting appreciation of my food-loving children.
I've taken over the kitchen temporarily, and I think that everyone will be glad when that period of our time is over.
Another example. So Marty had left practice to become a professor of law at Columbia Law School.
Oh, I didn't know that.
Then President Carter appointed me to the DC Circuit. Many people asked me, isn't it hard commuting between DC and New York? And I said, what makes you think that we're living in New York? And we didn't even discuss it. It was just the way things should be. He transferred from Columbia to Georgetown.
You mentioned your work at the ACLU Women's Rights Project. I mentioned this briefly in the article, how, at least in retrospect, many commentators, the first thing they talk about is the tactical brilliance of bringing these cases where men were complaining about gender distinctions in the law that they believed harmed them. Can you talk a little bit about that strategic choice? Was it a strategic choice? And second, do you think that the course of the court's jurisprudence would have been different had you only brought cases with female plaintiffs?
I have been complimented for mapping out this strategy. In truth, it's the cases that came trooping into the ACLU. The turning point case, Reed v. Reed, was a woman plaintiff, a law that discriminated blatantly against a woman, said, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Great first case. But then, let's talk about Stephen Weisenfeld's case, because his is a perfect example of what's wrong with drawing rigid lines based on gender. So Stephen was married to a teacher who had a very healthy pregnancy. She was in the classroom till the 9th month. She went to the hospital for the birth of the child. The doctor came out and told Stephen, you have a healthy baby boy, but your wife died of an embolism. So he, at that moment, decided that he would not work full-time until the baby, Jason, was going to school full-time. And he had heard that the Social Security system has benefits for a sole surviving parent with a child under the age of 12 in his care. He applied for that benefit and was told, well, we're sorry, Mr. Weisenfeld, these are mothers' benefits. Why mothers? Because mothers take care of children. Where did this discrimination begin? It began with the woman as wage earner. She paid the same Social Security taxes that a man paid, but her family did not get the same protection that a man's family would. That was the majority view of the court, that it was really discrimination against the woman. And then one, who later became my chief, he was then Justice Rehnquist, said, this is utterly irrational from the point of view of the baby. Why should the baby have the opportunity for the care of a sole surviving parent if that parent is female, but not if the parent is male? So that was my example of how these rigid gender lines in the law hurt everybody. They hurt the woman as wage earner, the male as parent, and the baby.
You think that the choice of plaintiff didn't necessarily alter the court's jurisprudence?
I think it helped them to see that gender discrimination created artificial barriers or disadvantages that increasingly were out of sync with the way people were living their lives. Or in another class of cases, women were automatically exempt from jury duty. So some people would think, isn't that pure favor to women? We had male plaintiffs whose complaint was to this effect. We don't mind doing our civic duty, but we don't want to have double duty. Women are citizens too. The point that we tried to make in those cases is that if you are a full citizen, you have obligations as well as rights. And one of those obligations is serving on a jury. If women are automatically exempt, then the society is saying women are expendable. Oh yes, if they want to serve, they can, but we don't really need them. We do need the men. So that message that the male citizen has obligations as well as rights, the female is expendable in our system of justice. That was another artificial line that was prevalent in the United States, even in my home state. Our test case was a man who was a doctor, and his wife was just graduating from law school. She had a clerkship. He stayed home that whole year and took care of the baby. He was called to jury duty. He shows up with his baby in his arms and asks for an exemption. And the person in charge of the jury clerk's office said, there's no exemption for you. I understand there's an exemption for women. Why do you have an exemption for women? Because women take care of babies. I take care of a baby. Ms. Magazine had a song collection. And the general title was Free to Be You and Me. And one of them was William Has a Doll, so it's okay for a boy to have a doll. And a girl could be whatever she wanted to be.